Before we dive into the materials today, we wanted to give you a roadmap of kind of what will we be talking about during this webinar. So if we can advance the slide, we have an agenda here. So first, we'll be talking about the purposes of an employee handbook, as well as different ways to structure employee handbooks. And then next, we'll talk about what's on a lot of people's minds right now, which is when and why should you update your employee handbook. So we'll walk through some of the reasons that you would typically update an employee handbook and potentially some of the updates you might be considering to add to your company's handbook. Next, we'll talk about how to communicate those updates with employees, and then whether and when you should seek acknowledgments of an initial handbook or handbook updates. And then we'll finally conclude with some overlaps between employee handbooks and employment agreements. And when we're happy to answer questions throughout the webinar, but at the end, if there's still time, we'll answer some of the questions in the Q&A. So first, we're going to talk about what are the purposes of an employee handbook. And this is helpful to understand because then companies can realize the importance of keeping their handbook updated, accessible, and clearly communicating the company's policies. So first, an employee handbook can be an employee resource. It can often be the first place that employees look to answer questions about company standards, expectations, operations, or looking for employee support in different life situations. An employee handbook can also set expectations in a changing work environment. So these policies can document employees' responsibilities and outline the potential disciplinary procedures if employees don't comply with company policy. The handbook can also meet different legal needs. So some states require that companies follow certain laws, such as anti-discrimination laws, or provide leave to employees in different situations, such as voting leave or jury duty leave. So an employee handbook can communicate that the company is complying with these laws to the company, as well as if there's ever an issue of whether the company is following the law, an employee handbook can be a place that the company points to as documentation that they were in fact complying with the law. There are also certain laws and policies that companies that are required to communicate to employees. So some companies, for example, might not want to pay out accrued but unused vacation if employees are terminating employment. Some states require it, but in other states, companies are not required to. So if a company does not want to pay out accrued but unused vacation, it often has to be included in the employee handbook, and it has to have a clear policy that the company will not be paying out accrued and unused vacation, so that employees are aware of this and it complies with the law of that state. Other states require that certain information be included in handbooks. For example, Virginia has statutory requirements that disability and pregnancy accommodations and information related to those accommodations have to be in a company's employee handbook. So it's a great way to meet the legal needs and requirements in different states. And finally, a handbook can create and strengthen a company's culture. So an employee handbook can be a place to answer employee questions and make sure that they're up to date with company policies, but also can provide support to employees if they're going through a difficult time in their personal lives. An employee handbook can answer questions about what support the company provides, but also ensure that the employee feels comfortable taking advantage of the company policies. An employee handbook can also foster unity and improve communication about the company's mission and company values. We're seeing an increasing trend of companies including their company mission statement or company values, information about the company culture in an employee handbook. And that's a way to kind of centralize it in one place and create a unified workforce. So before we dive into updates, it's helpful to talk about how employee handbooks can be structured. And we've seen a lot of different employee handbook structures in our experience in the companies that we work with. So here are some different ways that companies structure their employee handbook. First, some companies don't really use what we think of as a typical employee handbook, and instead they keep separate policies on a company intranet or another location where each policy is standalone. So employees can access just a leave policy if they'd like to, or just a policy about remote working if they need to, and all the policies are kept separately. And one of the advantages of this is that some policies, such as temporary policies related to COVID, might seem temporary, and so they can be kept separate from a full employee handbook and can just be accessible and updated as one-off policies. But there are some downsides to this approach as well. And we'll talk about also how these policies might overlap with employment contracts later in the webinar. So other reasons to keep these policies separate are that some policies are just meant to deal with regulatory bodies or meet regulatory needs. So if the policies are kept separately, the company could provide that policy to a regulatory body if needed without providing the company's full employee handbook. And they also could, a benefit of keeping policies separate is that if there's important policies, they could be called out separately and employees can be asked to read and acknowledge them without having to read through the entire employee handbook. However, a downside is it can be hard to keep all those policies updated and they're not really in one central document since they're separated into each individual policy. So another popular way that we see companies structure their employee handbook is that the company has one handbook and that employees, regardless of which state they work in, are all governed by the same policies. So for example, if a company has employees in 10 states, the company would look at the required laws in each of those 10 states and then create one company policy that complies with the law of each of those states. So for example, if California requires that companies provide bereavement leave to employees, then a company would provide bereavement leave to all of its employees, even though only a portion of its employees are located in California. So this is helpful because all employees are treated equally across the company and there aren't different standards or different benefits offered to certain employees based on which state they work in. And also all of the employee policies are in one handbook. And so this is accessible for employees to look at in one location for all of the handbook, as well as there's only one place that the company has to update these employment policies. The downside to this approach is that companies may be required to provide benefits to employees that they would not otherwise be legally required to provide. And this could be costly to a company. So depending on where the company has employees and how many employees are in each state, this approach may or may not make sense for a particular company. Another approach that we've seen to structuring employee handbooks is that there's one employee handbook, but employees are governed by their particular state laws. So this means that the handbook would have different provisions that apply to employees based on the state where the employee is working. For example, an employee handbook would have a jury duty leave policy, but then within that jury duty leave section of the employee handbook, there would be a California jury duty leave policy, a Colorado jury duty leave policy, and then a Washington jury duty leave policy. So each state would have a specific provision within the employee handbook. So the benefit of this approach is that the company can comply with each state law without providing additional benefits to employees. So it could save the company money on that area. But a downside to this approach is that the employee handbook can be long and confusing. So employees might need to read through other sections that don't apply to them to get to the particular portion that does apply to their state. And also, as they're doing that, employees can look at the provisions and benefits provided to other employees. And this could create disunity in the workforce. If you're looking through and saying, oh, wow, my peer in California receives all of these benefits, but I don't because I work in Wyoming, that could create disunity in the workforce. And then a similar approach is that some companies have one handbook that applies to the entire company, but then they put the particular provisions for other states in an addenda or an appendix. So the benefit of this approach is similar to the benefit of the previous approach, where companies can comply with the laws in each state without having to provide additional benefits that they wouldn't be required to provide in certain states. And this approach can be easier for employees because if there's only one employee in California, for example, that California employee could go to the addenda or appendix and look through all of the additional policies that would apply to that employee without having to read through the entire handbook to get to them. And then another approach that we see is that some companies, if they have a portion of employees in different states, so oftentimes they would have one handbook that applies to each state. And that can obviously escalate very quickly if there are employees in a lot of states. A company wouldn't want to maintain 10 handbooks, for example, and keep those handbooks updated. But this approach can be really valuable if a company has, for example, employees in 2 states and the provisions and benefits to those employees are different. It might just be helpful at that point to have 2 separate employee handbooks. So as we start to think about the updates, first we need to think about how is the employee handbook structured and how would it make sense to add those updates to an employee handbook and how to communicate those to employees. So we'd like to ask a poll now based on our attendees, how does your company structure its employee handbook? Is it the first option where it has one handbook and all the provisions apply to all employees? Is there one handbook but has state-specific provisions? Is it a handbook with addenda for different state laws? Is there a separate handbook for each state, or is it a different approach that we haven't discussed? Okay, we'll give you maybe 10 more seconds to wrap it up, and I'm curious to see how our attendees structure their employee handbooks. Okay, let's go ahead and look at those results. Interesting. Okay, it looks like a majority, so about 47% of companies structure their handbook by having one handbook, and employees are all governed by the same policies. Obviously, this makes a lot of sense if you're only in one state, but maybe if you're only in a few states as well, it's easy to administer a handbook that has provisions that apply to all employees. And it looks like very few companies, our smallest portion, have a separate handbook for each state. So this is really interesting. Thank you for submitting your answers. Okay, so let's move on. So once you understand the purpose and structure of an employee handbook, then we look at what are the reasons why companies end up updating their employee handbook. One of the first ones is changes in the law. We've seen the employment law landscape change a lot in the past few years. And so legal changes are kind of an easy, obvious way to update your employee handbook. A second reason is the new employment landscape. And this means not as a result of a legal requirement, but maybe trends of how people are working and different considerations companies need to think about based on the new way we work. Another reason to update employee handbook is if the company has changed its operations or operates in a different way that's not indicated in a current policy. And then another one is if an employee has questions. So if an employee has a question about a company policy or procedure, and then the company goes to answer that question and realizes, oh, we don't have a policy that addresses this, or our current policy is vague and doesn't really address the employee's question, that's a great time to update the employee handbook to clarify that particular issue. And then an unfortunate time to update the employee handbook as a result of employment litigation. So if a company is sued for an employment issue and then realizes that the employee handbook could help clarify or reduce this problem, that's a time that we see companies updating their employee handbook. But obviously it's hopefully one that you can avoid by proactively updating your employee handbook and avoiding employment litigation. Okay, so before we talk about all these ways that companies update your employee handbook, we'd love to know, in our next poll question, how often does your company update its employee handbook if you update it as a matter of course? So do you revisit your handbook every year, every 6 months, more often than every 6 months, some other time period, or as needed if you realize there's a change in the law or an updated policy? And we've seen companies, this pace increase rapidly in the past few years. Previously, companies looked at their employee handbook every year or two, but we're seeing that that time period get shortened with the new employment laws that have been issued in the last couple of years. Okay, we'll give you a couple more seconds to answer this question, and then we'll show the results. Okay. Wow, so it looks like about a third of companies review their employee handbook every year, and another 40% review it as needed. And those are the two most popular options. So updating an employee handbook, as we talk with a lot of HR professionals, can often be an undesirable task, something that companies put off or don't like to do because it is so time consuming and administratively difficult. So it makes sense that companies only do that once a year or only as needed. Okay. So one of the easiest reasons for a company to update their employee handbook is because of legal changes. So changes in state or federal employment laws often require companies update their handbook. Employment laws are changing a lot more frequently than we've seen in the past. Some of these changes are driven by COVID-19, but we're also seeing increasing state, county, and local laws in a few different employment categories, such as paid leave, sick leave, family leave, vaccine policies, and other laws. Some of the hot areas of employment law right now also relate to increasing policies for domestic violence and sexual assault victims, as well as policies addressing the legalization of marijuana in several states, as well as increased protected classes in anti-discrimination policies. So we're seeing some states expand what it means to be a protected class in a discrimination policy And a lot of those require updates in companies' employee handbooks. Paid sick leave is a popular area right now. So Colorado implemented a paid sick leave policy that will start applying to all companies in Colorado. It was previously limited to only those with 16 or more employees, but it's being expanded to all companies starting January 1 of next year. And companies are required to provide 48 hours of paid sick leave per year for sickness, injury, or illness of an employee or their family member, for public health emergencies, also for reasons related to domestic abuse, sexual assault, or harassment. So that's just one example of a paid sick leave, but we've seen these issued in several other states and counties and some cities even. FMLA, or paid parental leave policies, are a big area of focus right now in the employment landscape. So Connecticut recently issued a paid family and medical leave law that goes into effect on January 1 of next year. So a lot of companies are updating their handbook to reflect that new law. That new law in Connecticut requires all companies to provide 12 weeks of paid leave for employees or their family members who are experiencing a serious health condition, caring for a new child, either by birth or adoption, serving as an organ or bone marrow donor, or for victims of family violence. Connecticut previously had an FMLA policy, but this one's being expanded to provide paid leave to those individuals. And also, previously it was 16 weeks of unpaid leave, but now it's being 12 weeks of paid leave for employees. And the payment is actually coming from a separate third-party regulatory body. So companies themselves aren't paying for the paid leave. It's through a different Connecticut paid leave authority. Another popular area right now is providing paid leave for employees to receive COVID-19 vaccines and to recover from side effects of the vaccine. So obviously there's a federal law under consideration right now, but also states have laws on this issue. For example, New York has a COVID-19 vaccine leave law that requires companies provide leave, a sufficient amount of leave for employees to be vaccinated for COVID-19 and recover from side effects. The law itself doesn't define what a sufficient period of time is, but the period of paid leave that companies are required to provide can be capped at 4 hours per dose. So that would be 8 hours if employees receive a 2-dose vaccine. So as a lot of you are probably watching, one of the biggest issues in the employment law landscape right now is that the federal OSHA issued a vaccine or testing mandate in early November that is now kind of embroiled in litigation. So OSHA issued an emergency temporary standard in early November that requires companies with 100 or more employees to either require employees to be vaccinated or allow employees to be tested at least weekly for COVID-19 in order to enter the workplace. And companies also have a paid time off requirement where they must provide paid time off for the employees to receive their primary vaccine doses and to recover from the side effects of vaccines. But immediately after the ETS were issued, the Court of Appeals for the Fifth Circuit put a stay on the ETS, and several other states sued on this ETS as well. So it's all of the litigation has been consolidated, and the Sixth Circuit Court of Appeals has been selected to review the stay. And that's in process right now. So we're kind of waiting on different briefing or legal deadlines on that litigation. And the next upcoming deadline is next Tuesday, December 7th, where parties are required to submit responses to motions regarding the stay. And then there's another deadline on December 10th to reply to those motions. So given these deadlines, it's unlikely that the ETS will continue, or it is likely that the ETS will continue to be stayed until probably December 10th, if not later, which is past the original deadline that the ETS had of December 6th, which was the original compliance deadline. The Sixth Circuit could lift the stay before then, but really a lot is up in the air. So we're waiting for further guidance on that issue, but that will definitely dictate companies' vaccine policies and their COVID-19 policies. So besides legal changes, another big driver of reasons to update employee handbooks comes as a result of new employment landscapes or new trends in the employment law area. So let's go ahead and advance to the next slide. And we would love to know some of these that we'll talk about that there may not be required policies, but that we're seeing a lot of companies implement. We would love to know which of these new policies have your company implemented in the past 2 years. And you can select as many of these as your company has implemented or revised significantly in the past couple of years. So a remote working policy, health and safety policy, relocation, video conferencing, home office reimbursement, and desk hoteling. A lot of these have come as a result of the new way that employees work and is because of COVID-19. So we'll talk more about these, but we'd love to know which one of these your companies have implemented or revised. Okay, we'll give you about 5 more seconds to answer this. Okay, let's go ahead and look at which policies have been implemented. Wow, 83% of companies have implemented or significantly revised the remote working policy. That's huge. And then 60% have implemented health and safety policies. Smaller amounts have implemented relocation or desk hoteling, but looks like a third of companies have implemented video conferencing or home office reimbursement policies. So we'll talk more about each of these policies and why companies might need to consider them, how they could benefit your company, or help employees understand the company's expectations. Okay, perfect. Let's go ahead and advance to the next slide. Obviously, a lot of employees have shifted to remote working as a result of COVID-19, and this affects remote working policies. So historically, remote working policies may have been more rigid and required that employees obtain permission before working remotely or obtain approval of a particular remote working schedule. But now those have changed a lot, and companies should revisit their remote working policy to make sure it affects how and addresses how employees are actually working remotely now. And also this affects how the leave policies that companies might want to include in their employee handbook. Leave policies have been the front and center of the employment landscape in the past couple of years. In 2020, we saw the federal Families First Coronavirus Response Act that provided paid leave for workers who had COVID-19 or whose children or childcare providers were unable to provide care due to the pandemic. That federal law has since expired, but that paid leave requirements have trickled down to states and counties and local jurisdictions that now have similar laws requiring companies to provide paid leave to employees in those particular situations. And some companies have just voluntarily decided to provide additional paid leave to employees to deal with the COVID-19 pandemic, whether that's to receive vaccines, to care for children because of exposure to COVID-19. So that's something that your company should think about is, does our leave policy reflect how we provide leave to employees as a result of the pandemic? Health and safety policies look a lot different now than they did a few years ago. Many companies didn't even have health and safety policies, but now we're seeing almost all companies implement some version of a health and safety policy. Federal and state occupational safety and health administrations, or OSHAs, require companies provide a working environment that is free from recognized hazards that are causing or are likely to cause death or serious physical harm. So many state, federal, and local entities have issued different guidance on how to keep employees safe during the pandemic. And those should be reflected in how your company works, making sure that your company is complying with all of those guidelines that affect keeping employees safe. So Cal OSHA has been one of the leading bodies regulating this area, and Cal OSHA requires a lot of different things for California companies. But one of those is that companies in California are required to screen employees for COVID-19 symptoms before entering the workplace. So a health and safety policy should address that the company is screening employees. How will that screening take place? What will be the result of different screening? If the employee has exposure, what will happen? If the employee has COVID-19, what will happen? And how the company responds to different COVID-19 situations. Relocation policies are also a big focus during the pandemic. So a lot of employees may have relocated because they can work exclusively remotely, but where the employees are actually working, the state where the employee is working can have significant legal and tax consequences to a company, because those state and local laws will govern the employment relationship. So employees who are working remotely may not be aware of these consequences of moving to a new state or county, and may not notify the company until after the employee has already permanently relocated. So a company should have a clear relocation policy and indicate the implications of relocation so employees understand why the company is asking this information, and also ensure that employees obtain permission or at least provide a certain period of notice before relocating. And if the company already has employees in various states, the company might be willing to pre-authorize certain relocations, such as saying employees can relocate to these 5 states without obtaining prior permission. because not all of relocations have those different legal and tax repercussions, but at very minimum, the company should know where its employees are working and have a current address for all of its employees. A video conferencing policy is a wise policy to have due to the increase of video conference calls. So video conferencing quickly became the new normal during the pandemic, and a lot of companies weren't prepared for it. So video conferencing policies can be much more than just Zoom backgrounds. A video conferencing policy can address the appropriate platforms, the appropriate video conferencing platforms that employees should use, different confidentiality issues, such as when and how to record meetings and to obtain consent and what to do with those recordings, as well as security measures for video conferencing, dress code requirements that might be different on video calls than the dress code policy in the office, and desired uses of virtual backgrounds if the company has a position on those, and other etiquette. And not just for video conferencing, but the dress code policy of a company might need to be revisited. So dress code policies might be outdated now that employees are working remotely. So companies should revisit their dress code policy and ensure that it has appropriate attire for employees in the workplace and also employees who are working remotely if there's a different standard. And dress code policies should be reviewed periodically to ensure they are inclusive of all employees and not discriminatory. So policies should not say that men can wear different styles that women cannot wear, or vice versa, because this could alienate certain employees, especially transgender employees, and potentially lead to discrimination lawsuits. Reimbursement policies have been revisited a lot frequently. So with a shift to remote working, some companies permitted employees to purchase equipment to establish a home office. So reimbursement policy can address how employees can submit reimbursement, if pre-approval is needed for a particular purchase, and if employees are required to return any property if they're terminated within a certain period of time after purchase. And that segues right into company property policies. With the increasing crossover between employees' personal and professional workplaces, the lines are more blurry on how to appropriately use company property. So some employees have transferred company property to their homes during the pandemic. And so a robust company property policy can consider how employees can use company property, such as laptops and phones, whether employees can use that property for personal use, if there are any limitations on using that property for personal use, and then when and how employees are required to return company property to the workplace, either if the company is returning to the office or if employees are terminating, if their employment is terminated, when and how they should return that property to the workplace. And finally, desk hoteling policies are now on companies' radars. Some companies shifted from permanent assigned workplaces to a desk hoteling system where employees don't have a permanent desk, but they can reserve a desk to use temporarily for either a day or a week-long period. So a desk hoteling policy can indicate the company's guidelines of how this system is used, different etiquette for the workstation, etc. So there are a lot of reasons that companies can update their employee handbooks. Some of these are the legal updates, and some of them are the changed employment landscape. So now I'm going to turn the time over to Ryan, and he's going to talk about some additional reasons that companies might want to update their employee handbook.
And Adrienne did a great job of covering changes in the law and changes in the circumstances in which your company is operating. That could be new offices or other things. Another reason that companies need to be aware of for updating their employee handbooks is changing practices. And essentially what this means is that often companies will they'll adopt a policy in their handbook, and then over time, they will start to adopt a different policy in practice. And sometimes this can happen because of changing circumstances or other things. I'll give you an example. A lot of companies had remote work policies that, for example, permitted their employees to work from home 1 day a week. When the pandemic struck and workforces were sent home to work remotely, they were using these same policies that really only allowed employees to work from home 1 day a week to sort of govern how employees were working at home full time, and they had to quickly make adjustments. Often, however, it isn't a situation that is quite that stark, and what will happen is companies' practices, for example, regarding reimbursement, will start to change as managers who maybe aren't familiar with the employee handbook start to do things differently. And it's important that companies make sure that they're practices and their policies are consistent. If they're not consistent, that can cause a number of different problems for a company, including causing confusion among employees, eroding the utility of the employee handbook. If employees are looking in their handbook and they're seeing sort of one policy, a policy that's not followed, they may have questions about the utility of the other policies. And finally, it can create a legal risk. If the company has expectations that are set forth in the handbook, but they don't actually follow those expectations themselves, I think that can put a company in a difficult spot if there's litigation over someone not following policies in a handbook. So there are several ways for a company to keep its policies and practices consistent. And I think companies have different ways of doing this, but three that we've seen that are helpful. One is to make your handbook easy and to access and understand. If employees are able to go to the handbook and to understand and find the policies that they need, it's easy for them to follow those policies in practice. If a handbook is difficult to access or to understand, if it's written in legalese, I think employees are going to have a harder time knowing how they should respond to different situations. Second, companies can regularly train their employees on company policies. When a new employee starts, they can give them the handbook. They can talk through policies for things like reimbursement or dress code or remote work. And they can have periodic trainings to help reinforce a company's policies. And that could be a helpful way to make sure that the policies and practices stay the same. And finally, it's critical that companies inform employees of policy changes and have them acknowledge that they have read and understand them. And we're going to talk about communicating changes and acknowledgements. So there are two areas that we get a lot of questions about, and I think that companies do differently and sometimes companies struggle with. Let me just say that changing practices, I think, can be a difficult area for companies to keep their finger on, because if you have an HR professional or a member of your general counsel team that's in charge of updating the handbook, they may not know what the practices are outside of their department or in a satellite office. And so it's really important that you have buy-in from your leadership to make sure that your policies and your practices are the same. Let's talk for a moment about communicating changes. And this is a question that we get quite a bit. So when and how are you going to communicate updates? When the law changes, when your situation changes, when you realize that one of your policies is out of step with your practices and you want to bring those back in step, and you change your policy, how are you going to communicate it, and what are you going to do about it to make sure that your employees are aware? So first, there are different ways that companies are choosing to communicate changes. One is as they happen. If they change a policy, some companies are sending out a notice every time they change a policy. And there are some advantages to that. They could do it quickly. There's not a lag between maybe when they would change a policy and when the employee learns about it. One of the drawbacks can be in a large company where there are policy changes that are happening somewhat frequently. Say you're a company that's in a lot of different states, and states are changing laws that require changes in your policy. You may have to send out a lot of handbook updates. And I think companies try to avoid sort of filling their employees' inboxes with handbook updates. Or you could do it periodically. And we see some companies that are changing their handbook on a yearly basis, on a quarterly basis, on a monthly basis. We have an employee handbook tool set that we provide to companies, and for our customers, we send out a monthly update of all the changes to our employee handbook engine, because the law changes frequently and we're often adding new policies to our handbook. And so we encourage companies to update their handbook monthly, so they don't get into a situation where after a year they have to go back and find all the legal changes that occurred over the year. And some companies will wait 2 years, and you can imagine kind of what the burden is on them to go back and try to find all the changes that have happened over that 2-year period. The next question is how you're going to communicate policy updates with your employees. Email is a great way, and probably the most common way that we see. One advantage of email is that you have a record that an email has been sent. Typically with most programs, you can also see that an email has been opened. And so you have that record that at least changes to the handbook have been provided to employees. Training, again, is important. And I would say that's particularly important with supervisors who may be administering some of the policies, but for all employees, it's not enough to just give your employee handbook or give them access on their first day and then never talk to them again. continually having training and bringing attention to employee handbook issues can help you to make sure that you're communicating changes. And then acknowledgements. And this is the big one. This is probably the question that we get the most often from our handbook customers and the folks we work with on this issue is, when do we have to have individuals acknowledge a changed policy? And so I want to just ask a poll here, because we've seen companies do this in a lot of different ways. So we'll move to our next poll. And as that pops up, it'll be a poll about how, when your company seeks acknowledgments. So when does your company have employees acknowledge changes to your employee handbook? The first choice, whenever there is any change to the handbook. Whenever there is a significant change to the handbook, once a year. Less than once a year, meaning that maybe you send out an acknowledgement form every 18 months, 2 years, 3 years. Or some companies we talk to don't currently have a consistent practice. They're sometimes doing it when there's a change, sometimes they're trying to do it periodically, and they're still trying to figure that out. But acknowledgements is a big issue because it takes time and resources to get all of your employees to sign and acknowledge a handbook. So we'll give everyone just a couple more seconds to complete the poll, and then we'll look at the results here. And I'm interested to see, as I said, we've talked to companies that do a number of different things when it comes to acknowledgements. Why don't we pop up our results? Interesting. So about half of our respondents, and I'm surprised that it's this high, don't currently have a practice. And maybe I shouldn't be surprised, because that's why we get the questions, people reaching out saying, hey, how often should we have people acknowledge changes? I think that's really interesting. No one does it less than once a year. Once a year at just over a third, and 15% for whenever there is a significant change. I think, I've seen some companies moving to the significant change model, but I guess this isn't too surprising. I think once a year is probably the thing that we see the most often, that they will send out an email notifying their employees of significant changes. And then once a year, they'll have them re-acknowledge, meaning that they sign an acknowledgement form, or electronically sign an acknowledgement form, and then they keep a record of that acknowledgement. So that's an interesting, I think, an interesting poll. Let's just move to the next slide on acknowledgements before I turn the time over to Adam. So really, there are some pros and cons to each of these approaches. I think whenever there is a change, we didn't have anyone doing that, and I think that's for good reason. We have had companies ask us about that, but it's just too often. If you're going to have your employees sign a policy or acknowledge it online and keep a record of it, whenever there's a change, seems like it's a little over the top. Only when there's a significant change, I think, if you're allowing your employees to acknowledge online and it's a quick and somewhat painless process, I think that makes some sense. If you're still collecting, wet signatures on a piece of paper, I think that makes it a lot harder. Every year, I think, is a good way to do acknowledgements. And I think as a former litigator, I often think about litigation. And if you want to make sure that your employees understood your policy, I could see a good situation for businesses to be able to say, not only were they given our handbook when they started, but we have the exact date that they acknowledged that they had read and understood the handbook every year. And so they clearly knew what our company's policy was. Less than once a year, I think, is frankly less than ideal. I think once a year is a good practice, or if you feel comfortable with every time there's a significant change, as long as that's more than once a year. Less than once a year, I think you put yourself in a more difficult situation, but it depends on each company. I would say, as a best practice, you should have your employees acknowledge your handbook regularly, and make sure you keep a record of the acknowledgements. That way you can show that your employees understood your policies. So another question that we get somewhat frequently is, what provisions should be in a handbook versus kept separately? And Adrian addressed those, but the related question is, what should be in a handbook versus what should be in an employment contract? I'm going to turn the time over to Adam, who has helped to build our employment agreements tool set that includes employment contracts. And he's going to talk about some of the differences between the clauses in employee handbooks and those that are in employment contracts.
Thanks, Ryan. And yeah, so as we've been creating this new tool of employment agreements that are customized for all 50 states, we've been thinking a lot about the interaction between employee handbooks And employment contracts, what should be in one versus the other? What are the differences between the two? So both of them govern the employee-employer relationship, but there are important differences between the two and important reasons why you should separate out your handbooks from your employment contracts and have two separate documents. So employment contracts are legal documents that bind the employee and the employer to the terms and are enforceable in court. And that's really the upside, the big upside of a contract in comparison to a handbook, is that it creates binding legal obligations on both parties, the employer and the employee, that can be enforced in court. So there's a legal remedy for any breach of a provision in a contract. The downside is that employment contracts are fairly inflexible documents. So an employer cannot go in and unilaterally amend an employment contract. There's typically, you're going to need a written modification usually that both the employer and the employee have to sign. And depending on the nature of the change, the employer might have to give additional consideration or meaning some additional benefit to the employee, again, depending on what's being changed in the contract. And so, in contrast, employee handbooks are policy documents. They set out company policies and standards of conduct that are expected of employees, and they can be unilaterally modified by the employer. And that's obviously the big benefit in comparison to a contract, is that it can be changed fairly easily without having to go through all the requirements that you would have to change a contract. The downside is that, while if an employee breaches or violates a policy in your handbook that's probably grounds for termination, you wouldn't have a contractual remedy, right? You couldn't go to court and sue for breach of contract. And there are certain provisions that we'll talk about that are so important that you probably want to create binding legal obligations on the part of the employee. And we'll talk about those here in just a minute. So generally, employers don't want their handbooks to be considered contracts. And why is that? Well, because it would potentially create a huge set of new risks and liabilities for the employer, right? So all the policies would then create binding obligations on the part of the employer. So any deviation from that policy could potentially result in a breach of contract lawsuit by an employee. So employers go through great pains to make sure that their handbooks aren't considered binding contracts, and we'll talk about how to make sure to do that in just a second. But it's important to note that there are still risks for employers if you disregard your employee, the handbook policies, even if they're not considered contracts. So first, if you deviate from a normal policy, that can be evidence that you're treating one employee unfairly or different from other employees, which could be used as evidence in a wrongful termination suit or a discrimination lawsuit. It also has effects on eligibility for unemployment. So in many states, if an employee is fired for misconduct, that employee might not be entitled to unemployment benefits. And if the termination was for violation of a policy, the employer may need to show that that policy was regularly and uniformly enforced. And then finally, as Adrian talked about, some handbook policies are required by law, and they set out legal requirements. So, deviating from those policies may create some other legal theory that an employee could pursue in court, but violation of those policies wouldn't create a breach of contract, which most employers want and is very important. So how do you make sure that your handbook isn't creating a binding contract? So first, don't include specific and mandatory language binding the employer. So don't say things like the employer must do this or the employer shall do this. You're going to want to give the company a little more wiggle room in your handbook. Also, and this is common in common language in handbooks, you're going to want to include a contract disclaimer, specific language, right? This is a policy document that is not a binding contract on the parties. And you're also going to want to include language that the employer can change the policies in the handbook at its sole discretion at any time. And that language should be clear and prominent in your handbook. So again, having handbooks and contracts separate, it's going to allow your company to maintain the flexibility of changing the handbook while also making sure that certain really important provisions, which we'll talk about, are contractual in nature and legally binding. And we have a poll here for you now. We are curious if your company uses only employee handbooks, only employee contracts, neither or both. And we'll give you just a few maybe 10 or 15 seconds to answer that. All right, let's look at our answers here. So it looks like most of the over 60% of company representatives on the call on the webinar here use both employee handbooks and contracts. I would say that's probably a best practice, and we'll talk more about that. Looks like a little over 10% use only contracts and a quarter use only handbooks. So that's interesting. So that helps us transition to the next slide, and we're going to talk about specific provisions that are important to include in contracts, either in addition to your handbook or instead of in your handbook. And the first provision would be an arbitration provision. And so, as you probably know, arbitration is where employers and employees give up their rights to file a lawsuit in court, and they agree to resolve any dispute through a private dispute resolution process. Employers should typically not rely only on a handbook policy for arbitration requirements or arbitration provisions. So to ensure that your arbitration agreements are enforceable, you're going to want those to be in a binding contract that shows unambiguous acceptance by the employee. And that's really where companies run into trouble by including them only in handbooks. It doesn't hurt to have your arbitration policy set out in a handbook, and you may also want to do that. And there are some circumstances where only having an arbitration provision in a handbook could be enforceable. For example, if your handbook includes specific language that the employee's continued employment is going to constitute acceptance of the arbitration agreement. And also if your handbook can't include that important disclaimer language we talked about, which you're going to want in there, right? So that you're not creating a binding contract for your handbook policy. So, if you have an arbitration provision in your handbook and you don't use that disclaimer language, then you're going to risk other policies in the handbook being construed as contractual in nature instead of just policies. So, an employee's just reviewing an agreement to arbitrate in a handbook typically isn't going to be sufficient to form a contract, which you need for your arbitration provision to be enforceable. And that's why it's really best to include an arbitration provision in a contract that creates unambiguous legal obligations. And again, having it separate allows you to keep that really important disclaimer that you need in your handbook. If you are in a company that doesn't use employment agreements at all, or only uses them for certain employees, first you may want to reconsider that approach if you're not using employee agreements at all. But if that is your situation, you probably want to consider having an employee sign a standalone arbitration agreement that is separate from the handbook and clearly documents the employee's acceptance of the arbitration agreement. So there's no question that the employee has accepted that arbitration agreement. And if you do have arbitration policy language in your handbook and also a provision in a contract, you're just going to want to make sure that those are consistent. All right, we have one last poll for you here. We are curious if your company uses if you do use arbitration agreements, do you have those set out in a handbook, in a contract, or both? And we'll give you a few seconds to answer that here. All right, let's take a look at our results. All right, so over a third of your companies don't use arbitration agreements. For those of you that do, it's only in a contract. 15%, it's only in a handbook. And for a few of you, it's both. So for those where it's only in the handbook, you want to think about the issues we've raised here today and make sure that one, it's going to need to be a binding contract. But if you do have that in a handbook and you're creating a binding contract, you're going to want to be careful to make sure your other policies aren't creating a binding legal contractual obligations. All right, let's move to our last slide here. Another set of legal areas or provisions that you're going to want to include in a contract as opposed to a handbook are confidentiality provisions and restrictive covenants. So we're talking about non-disclosure agreements, non-competition agreements, and non-solicitation agreements. So if you have those only in a handbook, again, let's take confidentiality, for example. If you have a confidentiality provision or non-disclosure provision or policy in your handbook and an employee violates that, again, that may be grounds to terminate the employee, but it won't give you any legal remedy to go to court to pursue some sort of remedy in court. And most companies think that confidentiality provisions are so important that they want to have those in an employment contract, right? So those provisions are protecting a company's trade secrets and confidential information. And so again, most employers want to create binding legal obligations on the part of the employee there. And so if it's only in a handbook, again, there's not going to be a legal remedy in court under a contract theory, at least. Same goes for non-compete and non-solicitation provisions. So, non-compete agreements keep employees from competing with your company for a certain amount of time in a certain geographic area after employment. And if you have them in a handbook that applies to all employees, they're probably going to be unenforceable for a couple of reasons. One is that non-competes if you use a one-size-fits-all approach for non-competes, it's not going to be enforceable. And why is that? Because non-competes have to be supported by some legitimate business interest. For example, protecting company trade secrets. And if you're using non-compete agreements for your lowest level, low-wage employees, it's probably not going to be protecting a legitimate interest. And depending on the state, it may even be unlawful to use non-competes for those employees. So that's one reason you don't want them to be in an employee handbook. And two, again, same thing with arbitration. You probably don't want your handbook to be creating binding contractual obligations, but to be enforceable, your non-compete needs to be a binding contractual obligation that the employee has unambiguously accepted. And so, in almost every state, the law looks unfavorably upon non-competes because they restrict people's ability to work and make a living. And so if these provisions aren't in a signed contract, they really almost have no chance of being enforceable. So that's why you're going to want those provisions to be in an employment contract. The key takeaways, I think, here are that you probably want to keep your employee handbook and your contracts separate. Make sure that your handbook contains the appropriate disclaimer language so that it's not considered a binding contract, but then put important provisions like arbitration, non-disclosure, non-compete, non-solicitation provisions in your contract so that the company has a legal remedy if the employee breaches those obligations. And so that brings us to the end of our presentation here. Marie, do we have any outstanding questions that we need to answer?
We have actually answered all of the questions in the chat. So thank you everybody who submitted those, and to Adrian and everyone else who helped answer them in the chat.
Great. Well, thank you everyone for joining us today. I think we've had a really good discussion, and we hope that the information that we presented was helpful. If you want to learn more about 650's automated employee handbook and agreements tools that we've created, you can follow the link that we shared in the chat at the beginning of the webinar. And with that, we thank you again for joining and hope you have a great rest of your day.